the Government of Alberta.
Thank you very much and good afternoon. Minister Freeland, I have just two questions for you this afternoon. As has been discussed today, I apologize for the transcript. My name is Mandy England and I'm one of the lawyers for the Government of Alberta. As has been discussed today, you had consultations with the CEOs of several banks on February the 13th about potential economic measures. And you said in your testimony today how important it was for you to hear from the leaders of the financial institutions what their views were on the situation with the blockades. And as you're also aware, the consultation with the First Ministers of the provinces and territories was held on the morning of February 14th. And that was after the cabinet meetings and the IRG meetings had been held. Now, consulting with the CEOs of financial institutions for their views on the situation is not required by the Emergencies Act before the government can invoke the Act for a public order emergency. But consulting with the provinces and territories for their input is required. As Deputy Prime Minister, don't you think that the input of the First Ministers of the provinces and territories on the potential invocation of the Emergencies Act and the proposed measures would have been relevant information to have before you at the IRG meetings and the cabinet meetings where the invocation of the Emergencies Act was discussed and debated?
Thank you for the question. And as a former intergovernmental relations minister, I understand it, and I really do understand the importance and sometimes the challenges of that federal-provincial relationship. In this particular situation, it was a very complex, fast-developing situation, and each minister was responsible for managing a series of relationships and bringing that information to the table. My colleague, Dominic LeBlanc, is an extremely able minister, an extremely able intergovernmental affairs minister, and I relied on him, as did everyone around the table, to manage that relationship and to bring to us and to the table his knowledge of the views of the provinces and territories.
And with your knowledge that they weren't consulted or about the Emergencies Act or told until the morning of February the 14th that the Emergencies Act might be invoked, wouldn't you agree that the information on their views on the potential invocation of the Emergencies Act wasn't before the cabinet or the IRG? It wasn't one of the items because it wasn't available until February the 14th?
In my view, Minister LeBlanc very effectively, from what I could see, very effectively communicated with the provinces and territories and communicated with us what he learned from those conversations. That discussion that happened on the Monday was important. I wasn't part of that discussion, but it happened and it was important that it happened.
And so the evidence that has been given before this inquiry is that the Emergencies Act had not been raised with any of the First Ministers of the provinces or territories or any of the cabinet members of the provinces or territories. So wouldn't you agree with me that whatever information it was that Minister LeBlanc was bringing to the table, it did not involve discussions about the Federal Emergencies Act?
Again, there I would say this was an area of responsibility for Minister LeBlanc, who I do absolutely believe does that very difficult job very well. And I had confidence in how he did that job.
I'll move on to my second question. We spoke about the call that you had with the banks on February the 13th. There was another call with the banks on February the 21st, and I'd like to just pull up the readout from that call, if I may. It's ssm.can 401828. And the section that I'd like to draw your attention to is close to the top. It's the portion that reads from DPM, which I take to be indicating that this is what you said on the call as Deputy Prime Minister would be DPM. Is that correct?
I think so.
Okay, thank you. And then the there's a paragraph that begins first, and then the next little paragraph says, the RCMP has told us they have heard from protesters as they were leaving the blockades that they did so because their families said their accounts were frozen, so get the hell out of there. This is a much better and peaceful way to end things. Now, freezing someone's bank account without due process engages their personal rights. And it also engages the personal rights of the families that shared many of those bank accounts, individuals who weren't even at the protest. You've stated here in this document that your view was that this is better and more peaceful, presumably than using the existing legal authorities, which multiple branches of law enforcement have testified at this inquiry were adequate to bring a peaceful end to the protests. And indeed, they did so using those authorities. So do you still hold that view today, that freezing the accounts was a better solution than law enforcement carrying out its legal authorities in the responsible manner that they do?
The view that I do hold, as we discussed earlier today, is one of my very grave concerns about bringing these illegal blockades and this illegal occupation to an end was the danger that there would be violence, and that there would be violence directed towards the protesters. I was particularly concerned because of reports that children were present. And that was one of the reasons that I felt the financial tools that were put in place by the Emergencies Act were a better option. From my perspective, the job of these tools was to create a peaceful, nonviolent incentive for people who were doing something illegal to leave. And I think those tools did work.
And so I would just remind you in that regard that the call that we're looking at this readout from in front of us was held on February the 21st. And so at that time, the Coutts blockade, we can scroll up to the top of the document. We have Monday, February the 21st, and you say, it's hard to believe it was only a week ago. We were on a call last Sunday, which was February the 13th, talking about this. So this is a call that was held on February the 21st, after the enforcement actions had been taken out at Coutts, which were done before the Emergencies Act was invoked, after the Ambassador Bridge was cleared, which was before the Emergencies Act was invoked, and while the enforcement efforts in Ottawa were well underway, and you would have had the knowledge at that time that there was peaceful resolution by law enforcement at both of those border blockades, and that there was no violence against children, and it was a peaceful resolution by law enforcement in Ottawa. And so with respect to those comments about the fear of the prospect of violence, I don't know that on the timeline of February 21st, are you saying you still had them then and you would still have those today?
No, not at all.
And so you expressed this view after you were of the knowledge that there's...
May I explain?
Absolutely. I didn't realize you were talking. I apologize.
No problem. It can be hard on the video calls. So on February 21st, when I made those comments, it was looking back on the events of the week that had passed. And I certainly believed then, and I believe today, that the financial tools we put in place aided in the peaceful resolution of all of those occupations and blockades. The reports that we heard, the reports that were in the media, the reports from law enforcement were that many people did leave as a result of the incentives created by those tools. And then the final thing that I think is important to emphasize is we said on February 14th, we are putting these tools in place, so please leave now, so that these tools never need to be used. So any person who had their account frozen had due warning that they were engaged in illegal activity and that they should stop doing that activity. And the other thing that I would point to that I think did work well is the accounts were very quickly unfrozen after the illegal activity ceased.
And with respect to the due warning, there were, as you acknowledged in your earlier testimony, accounts of families, individuals who weren't present at the protests that were also frozen. Would your view be the same with respect to those individuals?
Again, that was never the intent, that to in any way affect family members. Certainly the consequence, the reality of people having joint bank accounts made that impossible to entirely avoid. But I would say that the family members whose presence at the protest, at the illegal occupation and blockades, caused the accounts to be frozen, had a very easy, readily available remedy with a lot of notice. They could have left before the freezing began, and as soon as people did leave, the accounts were unfrozen.
Thank you, Minister. Those are my questions today.
Okay, thank you.